Good morning, good afternoon, and good evening, and welcome to UCL. I'm Dr. Danae Azaria. I am Associate Professor at UCL Laws, co-convener of the ILA Lecture Series at UCL, and convener of the ILC Event Series at UCL. It is my pleasure to chair today a joint event of the two series, having as speaker Professor Shinya Murase. Professor Murase is Professor Emeritus of Sophia University in Tokyo. He has published widely in the field of public international law, and one of his major publications is his book entitled International Law, an Integrative Perspective on Transboundary Issues. Having read the book and his work on the International Law Commission and on the Institut de Droit International, to my mind, this very approach transcends his thought and vision as an international lawyer. Professor Murase obtained an SJD from the University of Tokyo in 1972. He was a visiting research fellow at Harvard Law School in 1974 to 1976 and a visiting professor at Columbia Law School in 1995. He worked for the Codification Division of the Office of Legal Affairs of the United Nations Secretariat between 1980 and 1982. And since 2009, he has been a member of the United Nations International Law Commission, the ILC. I admit that when I initially decided to invite Professor Murase to give this year's ILC lecture, I envisaged that he would discuss his excellent work on the very important and timely topic on the protection of the atmosphere, on which the ILC works since 2013 and for which Professor Murase is the special rapporteur. This topic was to be considered at second and final reading in the ILC session last year. However, that session was cancelled owing to the COVID-19 pandemic, and instead the Commission will be considering the second reading of this topic in the current session, this year's session, if everything, of course, goes to plan. And of course, we all hope that it will go to plan, especially because the Commission is considering important topics this year, including the one on the protection of the atmosphere. However, during the pandemic, Professor Murase, who has also been a member of the Institut de Droit International since 2011, took a new role as a rapporteur of the Institut on epidemics and international law. To my mind, this is a great initiative of the Institut and evidence of how international lawyers in general, and Professor Murase in particular, have been dedicated to contributing and helping in the way that they can in the fight against the global pandemic. It is thus this topic that Professor Murase will talk about today, the work of the Institut de Droit International on epidemics and international law. A report of the Institut is expected to be published by June 2021. I have had the privilege to read earlier versions of this report, and I can attest to the significance of its breadth, approach, and analysis. It is also important to mention that Professor Murase, who was a member of the Curatorium of the Hague Academy of International Law from 2004 to 2016, now serves as co-director of the Hague Academy Center for Studies and Research on Epidemics and International Law, and that the center's monograph on that topic will also be published in August 2021. Please feel free to place your questions in the Q&A box and we will answer them at the end of the lecture. And so without further ado, I give the floor to Professor Murase.
Thank you, Professor Azaria, for your very kind introduction. It is my great pleasure to speak to you. This is a large audience, in fact, and so I'm going to share my my PPT. So this is my outline for tonight. I'll introduce the topic and so I'll talk about the history, interrelationships, and a little bit of the IDI, Institut de Droit International draft articles. You know, Professor Azaria talked about my role as special rapporteur for the International Law Commission on the protection of the atmosphere. I find this topic epidemics and international law are quite similar because atmosphere and epidemics are quite similar to in their legal characteristics. So speaking on the history of epidemics, the first recorded epidemic in history was Thucydides' history of the war. It was he writes that the plague of Athens, this is the first recorded epidemic, but 5 centuries BC. There were 10,000 deaths, no, 100,000 deaths, which was 1/3 of the Greek, Athens population. Well, this was the first case of what is called Thucydides trap, and the invading Spartan army had to abandon military control of Athens due to epidemics. This means that epidemics considerations overrided the military strategy. Anyway, we have the humankinds have faced epidemics from the beginning of the history, and we have so many incidents from the ancient Roman period to the modern Europe. Spanish flu in early 20th century killed 50 to 100 million people and so forth. In this century, we have had SARS, dengue, Ebola, influenza, MERS, Zika, and now COVID-19. And we have had 3 million or so deaths so far for this current coronavirus. Well, international law relating to epidemics may start in the medieval Europe. In the 14th century, the state of Emilia implemented the border closure against pest. The Ragusa, the present-day Croatia, Dubrovnik, imposed a quarantine. And in the modern Europe, we have 1851 sanitary conference in Paris. The medical doctors proposed this conference in 1837, and it took them 14 years to actually open this this conference. So history goes to the League of Nations, etc. And in 1948, the WHO was established. Its constitution provides for the enjoyment of the highest attainable standard of health and promotion of health and control of disease, especially communicable disease, that is epidemics. Well, of course, the WHO has, and WHA, the assembly has a strong lawmaking power, and we have the international health regulations. The current one is 2005, which is the core of the WHO law. This IHR binds 196 states plus Liechtenstein and Holy See. The purpose of this document is to protect against control and provide a public health response to the international spread of disease. So one of the most important provision is Article 6, which provides that states is obliged to notify the WHO within 24 hours all events which may constitute a public health emergency of international concern. And Director General of WHO is given the power to declare public health emergency of international concern under Article 12. Well, in the course of COVID-19, we have faced many paradoxes of international law. The more human rights sometimes lead to more deaths. More economic activities sometimes leads to collapse of economic system. International solidarity and cooperation has been stressed, but the more calls, the more divisions among states. And stronger border controls, safeguarding security and safety of the population are no longer true for the prevention of epidemics, which is called the border paradox. Well, epidemics have been neglected for a long time in the mainstream international law. If you compare the number of deaths in World War I with the Spanish flu, the latter is 2 or 3 times as many. And as you know, since Hugo Grotius' law of war and peace in the 17th century, regulations of war and use of force has been placed at the center of the studies of international law. And also the UN Charter says in the preamble, to save the succeeding generations from the scourge of war is the purpose of the UN. But if you think about the serious threat of epidemics, the core of international law studies may have to be shifted from war to epidemics. Of course, the danger of war has not gone away, but the epidemics poses very serious problems. So I thought that the most important subtopic in this project is to clarify the interrelationship among the relevant rules of international law, because WHO law or international health regulation is not a confined, sealed, or self-contained regime. It is an open system. So we have to deal with the questions of international health law from the perspective of interrelationship with relevant rules of international law. So you will see that in the IRC, there was a report of the fragmentation study group led by Professor Matti Koskenniemi about harmonious and systematic interpretation and application of international law. And I depend on his research, the study group's research. And I went through all the individual branch of international law. First, human rights law. International Covenant on Economic and Cultural Rights is most closely related to health law. Article 12 provides for right to health and refers to epidemics. And Committee on Economic and Social Rights, General Comment 14 is most relevant for the interpretation of Article 12. International Covenant on Civil and Political Rights, ICCPR, is also closely related because if a state imposes emergency measures, then you have to face the question of limitations and derogations from ICCPR provisions. And there are three principles which should be considered, that is necessity, proportionality, and non-discrimination. And these are all relevant when we consider the restriction of the freedom of movement and freedom of expression, etc. International environmental law is really closely related to epidemics. There is a close linkage that has been pointed out by WHO and other treaty bodies on international environmental law. Of course, the obligation of due diligence developed by the Trail Smelter Arbitration and 1972 Stockholm Declaration is most relevant. Climate change has been cited as the causes of malaria, Ebola, dengue, and other epidemics. Loss of biodiversity is also mentioned as causes of epidemics. Related to biodiversity, zoonotic causes of epidemics, the consumption of wild animals, animal meats, have been said to have caused SARS, avian influenza, and other epidemics. International trade law is also relevant. WTO got Article 20 exceptions refer to life and health and human and animal plants, human health and life of animals and plants. And there have been two cases in WTO referring to epidemics. One is Brazil regarding the import of retreaded tires, old tires. Brazil complained if the old tires are imported into Brazil, they may become the habitat for mosquitoes and then cause malaria and other diseases. India complained some agricultural imports, agricultural products to be imported to India from the United States and Canada. And because of the influenza and WTO SPS agreements, sanitary and phytosanitary agreement is also relevant in these connections. As to the pharmaceutical products, WTO TRIPS agreement are relevant because the intellectual property of pharmaceutical products and vaccines are very much a problem especially for developing countries. And we have had Doha Amendment in this connection, but some more work needs to be done in this area. Well, international transport law is sometimes crucially relevant. We had the, Diamond Princess incident in Japan in January, February last year. This was the beginning of COVID-19 for Japan, because there were 3,000 or 4,000 people on board of the ship and 1,000 crews. The passengers were mostly old people. They are vulnerable to coronavirus. And the WHO advised us not to evacuate those passengers, and passengers wanted to get out. So it was a very tense moment for some time. But the ship was near the Yokohama port of Japan, but the ship went outside the territorial waters a few times. And so there was a confusion who is in charge of the ship. The owner of the ship was an American company, and the flag state of the ship was the UK, and the captain was an Italian. So this was a gray area in the law of the sea and maritime law, and this needs to be developed further. International law on peace and security and international humanitarian law was also relevant. And of course, the Security Council resolutions have been passed, but the Security Council has not been consistent in addressing epidemics as a matter of peace and security. So it needs to be further made consistent. International humanitarian law, the Geneva Conventions and additional protocols are also relevant. So in drafting draft articles for the Institute of Droit International, IDI, I had the inspiration from the ILC articles on protection of persons from disasters. This was completed in 2016, and Special Rapporteur was my good friend, Eduardo Valencia Uspina. I worked with him in the codification division, and he was the one who trained me when I joined the codification division. So he's a big brother for me. But anyway, this articles divide the project into three temporary phases: before, during, and after disasters. Incidentally, this ILC articles refer to disaster, but disaster here does not include epidemics. So I took it just for an analogy. Well, before epidemics, we need to conduct thorough risk reduction and preparedness. And especially we thought that epidemic impact assessment or environmental impact assessment relating to epidemics should be conducted, especially for food market, transportation sites, and all the facilities related to epidemics. During epidemics, of course, states exercise emergency measures. So for affected states, the reporting obligation comes first. The states affected should report to the WHO and other states about the unnatural or unexpected events or other events requiring emergency measures in order to protect other states from expanding the epidemics. This notification should be done within 24 hours after assessment. Other states should take preventative measures and offer of assistance should be considered. After epidemics, we need to conduct a thorough review, and of course, the issues of responsibility comes at this stage. Post-epidemic phase, as I said, we need to have a review committee and other reviews, independent oversight advisory committee, and outside WHO we may have a high-level inquiry by the UN itself. The issues of responsibility refers to state responsibility, as well as the responsibility of international organizations. And about the dispute settlement, of course, we need mutual consent among the states if we want to submit the case to international courts and tribunals. The domestic courts may take up some cases, but always the sovereign immunity issue is a bar for this for the domestic courts. In the exercise of Institute of International Law, IDI, there were a group of members of the commission composed of 15 members, group of members who says that we should refer to state responsibility in this project. Others said we should not refer to this issue. And so we ended up in the middle line. We just stated the obvious. So we refer to the RCWA Articles on Responsibility of State for Internationally Wrongful Act, Article 1 and 2. If there is a breach of international obligations, that would entail state responsibility. Of course, it doesn't say anything, but it says something. And actually, I think it's very difficult to invoke state responsibility because international law only deals with human activities, and we do not deal with natural phenomena. And of course, international law is not yet well developed to regulate epidemics. And it's always difficult to trace the causality. What is the origin of the act, and if there is any causal chain leading to the result, that is very difficult to prove. And even if there is causality and responsibility, force majeure, necessity, and distress will exempt the responsibility. And state may have little control over cessation and non-repetition, and reparation and compensation is very difficult to assess. So there is concrete difficulties in pursuing responsibility. So the project is much of international cooperation rather than seeking responsibility. But there may be some reference to be made in this connection in COVID-19 situation. There was a delay of notification to WHO on 30 December 2019. As you know, Dr. Li Wenlian, one of the doctors in Wuhan, alerted his colleagues by SNS, for which he was penalized by the local police. And China notified WHO on 23rd January, and lockdown of Wuhan was conducted on that day. but already millions of people were traveling before the 25 January Spring Festival, New Year. So this was one of the problems often cited. As to the responsibility of WHO as an international organization, well, Taiwan communicated to WHO in early December. I mean, it's late December 2019. That was 30 December, I think. But it was not considered by WHO. The WHO's declaration of public health emergency of international concern was 30 January, and travel restrictions were not recommended. This should be reviewed subsequently, and it is being reviewed. However, holding WHO responsible under international law is difficult because the IHR provisions are essentially recommendatory, leaving wide discretion for the Director General. So about exactly one year before, that was 17 March 2020, I woke up in the morning and I thought that we may need a new convention. And so I drafted a 7-page concept paper and I sent it to ILC, International Law Commission of the UN. But ILC's members, some members were very enthusiastic, but others were not very enthusiastic. And some of them said that we need to follow the regular procedure by placing this topic to a working group for long-term program work that would take at least 2 years, and then regular procedure for appointing special rapporteurs and complete the topic. We need maybe 10 years. So I sent this topic to IDI, Institut du Droit International. And then IDI moved very quickly. And so I started this work. And I really appreciated Professor Gianluca Birch. He's a former legal advisor of WHO who gave me a lot of suggestions and advice. ILC, I think, missed a precious opportunity to be relevant to the actual need of the international community as a whole. Anyway, we completed this report by the end of December 2020, and the report will be published as Professor Azaria mentioned. It will be published in the yearbook in June 2021, and it will be uploaded in the IDI website. And this will be considered by the Beijing conference in August, but it has just been decided that Beijing conference will be online as well. So I just give you the outline of the draft articles, which we hope will be the basis for future convention. And in the preamble, we said that epidemics is a common concern of humankind, and scope and objective and use of terms follow. As general principles, we have human rights, the role of the state, and international cooperation, as well as relationship among relevant rules, as I mentioned. And for the before epidemics considerations, risk reduction and preparedness. And for the obligations of states during epidemics, we have these provisions for obligations of the affected state, and also emergency measures, etc. For obligations of other states, preventative measures and offer of assistance. As for the measures in the post-epidemics, review and information sharing, so that it will be the lessons for future epidemics, and state responsibility and international organizations' responsibility follow, as well as the dispute settlement. So these are the the contents of draft articles. Well, of course, we have, as to the dispute settlement, we have no precedents in ICJ or PCA, because we always need mutual consent among states in order to establish jurisdiction. And in WTO, we have a compulsory jurisdiction, so we don't have to worry about mutual consent. But there are very few cases in WTO as well, apart from those two cases that I mentioned. In the cases of epidemics, scientific evidence is crucial. And Mariko Fukasaka wrote an excellent doctoral dissertation in UCL. She was my former student at Sophia University, so I'm proud of her. But anyway, I'm sorry I'm not very well organized, but this is the content of IDI, and I hope you will give us a lot of support. Thank you very much for your kind attention.
Thank you very much for this really insightful lecture, and a very comprehensive one, and also for to better understand the vision of the Institut de Droit International at the moment, and where this project is going, to hear that in fact the proposal is for a new convention in this area. Some of the questions would be expected, of course. So Shinya, I can perhaps start with the first one. The first question is, despite the previous epidemics, how do you see the discrepancies in international law in terms of contractual obligations? And I think that this particular question focuses on what force majeure is within cross-border contracts, other than the types of situations you were envisaging. Another question is, could you speak to the need for a plant-based food system, for instance, because scientific evidence such as presented by the IPCC shows an urgent shift towards that type of system, and that it is required to mitigate catastrophes. Do you think that this is a need? Should we just start with these two, and then we can continue with the WHO? I can see here some other questions.
Well, do you hear me?
Yes, yes.
The first, Muhammad Ali's question on discrepancies in international law. as I said, epidemics have been ignored in international law, or at least in the mainstream international law. And of course, the war and the use of force has been the center of international law from the 17th century when international law started. I don't know the reasons, but I guess in wars, the young people are killed in a brutal way, whereas in epidemics, the old people like me dies one by one quietly, so it didn't get much attention, and especially in international law, it was very difficult to hold states for the wrongdoing, and well, force majeure clauses in so many contracts. Well, this was really the lacuna in international law and in domestic law as well, in the contractual laws. So I guess it is the same reason of discrepancy that these were ignored in those clauses. I think Mr. Tiwari's question refers to the same issue, and I guess I really don't know the answer, but we have to see the development of the relevant law. Mm-hmm. That's all I can say right now for these two questions.
Paulina Morales is asking, what are your thoughts about the equal distribution of COVID-19 vaccine distribution and COVAX dealing with vaccine nationalism?
Well, I guess this is for the initially, primarily for the WHO people to answer. And I don't know if Professor Birch is attending, but this relates to the equity in international law. And of course, equity principle is very ambiguous, and it doesn't work for the actual operation. But still, this has been intensely debated from the viewpoint of equity in international law, and we have to see how the COVAX is going forward, and of course the intellectual property rights questions are so much relevant to the distribution of vaccines. So I'm sorry, I really don't know the answer.
I suppose one question that somehow builds on that is also whether human rights, the existing human rights obligations actually have something to say about equal distribution or not, and whether states even have these types of obligations for individuals that are placed beyond the territories or in other states, and how that would have an effect on the equal distribution of vaccination, for instance. Or whether there are limitations on territorial application limitations on human rights violations that prevent us claiming that human rights can have a say in this.
Yes, of course, the right to health is the basic principle of the Economic Rights Convention. But as you say, there is a restriction of the application of human rights conventions on the basis of, domestic implementation that is not to be applied extraterritorially. So, of course, you can argue that human rights protect vaccines for everybody, but I think we need a specific convention to deal with these issues.
I wonder, so I will take another question from Matilde. So Matilde is saying, what relationship do you believe your proposed convention will have to concept or doctrine such as the responsibility to protect, which has been used to justify epidemic-related interventions, for instance, in the case of the Ebola pandemic by the US?
Well, responsibility to protect was heatedly debated in the IRC in the context of disaster relief. But most members were not happy about this concept because R2P is a very intrusive concept. And of course, that comes in conflict with sovereignty of the affected state, as demonstrated in the 2008 incident relating to Myanmar. Mm-hmm. And I think this is the same as, mostly the same as in the case of epidemics. But maybe epidemics have more stronger basis for R2P. But again, I think we need a separate convention to justify the intrusive assistance to those affected. Otherwise, it will be unjustified intervention into the domestic affairs.
I have a question that it has to. I will focus on one aspect of the question. I'm trying to get to read properly everything and get a chance to everyone to ask. So Bonis Suarez is asking whether political leaders should be also included in a future convention in the sense of denying the prevention recommendations, violating quarantine and such recommendations. Would international criminal law have something to say here? Should it, in the first place, have something to say here?
Well, I don't know. This is a very bold statement. And I don't think this works under the existing international law, but we'll see how this develops.
Nishant Tiwari is asking that many countries during the pandemic proposed the dissolution of certain international bodies such as the World Health Organization, and we've seen other states not being prepared to comply or to withdraw from international organizations. What are your views on that? And I suppose building on that, the question is, if someone reads your report, it's pretty obvious what your views would be on that, because you're proposing closer international cooperation. But how do you feel about the nationalism that has been developing in the context of the pandemic? Which is the way forward?
You know, in the commission, I mean, the IDI commission, we were very careful not to interfere in the WHO affairs. We are not WHO law experts. And, you know, anything we say might be absurd. So we just wanted to avoid that situation. And I think that's for the WHO people to propose any amendments to their constitution or to their IHR. And so we'll wait for the recommendations that WHO makes. WHO remains the center of the business in protecting epidemics. So I'm not in favor of dissolution or anything like that. On the contrary, we need to support WHO. They're working in a very difficult situation, and we have to be very cooperative to their efforts.
Another question is, is there a possibility, there is a possibility of deliberate disease outbreak, and how does that, is this relevant for the project that you're undertaking, for instance, and what would be the law in relation to that possibility?
Well, if a state is trying to use epidemics as a weapon for, of course, this is the problem of international law in the context of arms control law. But I don't think that there have been any deliberate attempt to disseminate epidemics. So this is out of the scope that we have been trying under IDI. And of course, related to arms control, there was an incident in the Soviet Union period in Russia that some of the virus killed some of the scientists working for the the biological weapon institute there. So that kind of accidents may happen, and that's why we need to conduct environmental impact assessment to be imposed on epidemic-related facilities, including laboratories.
Perhaps I can ask a question, a more general question that relates to your proposal for the convention, and to see, well, there are so many questions I can ask, obviously, about that. But one major question is, what is the likelihood that states will actually take on this particular proposal? What do you think at the moment, at least? Is there an appetite? The second question in this respect is, I suppose you mentioned that this was proposed in the ILC, and that poses a question of whether the ILC is or should be the appropriate forum for this type of work, given its procedures. Both the Institute and the Commission are codification bodies, very different, of course, in terms of their style, nature, and framework in which they work, with the ILC having a clear direct relationship with states, while the Institute not having that. But I wonder, what have you experienced, having been a member of both bodies? What is your view at the end? Because you have now concluded this work in the Institute. So how do you understand the two bodies in relation to epidemics?
Well, it's a very difficult question because I don't think I'm living long enough to see the result. But if you look at the international lawmaking activities of the 20th century, I think the biggest achievement in the 20th century was the Law of the Sea Convention. And that started by a speech of the Ambassador Pardo of Malta. Malta is a very small country in the Mediterranean. But he paved the way to the 1982 convention. And I met him once, and I was very much impressed. So if somebody who has listened to this, who have attended this session, may think of an international lawmaking project in 10 or 20 years, when the epidemics situation is become worse and worse, then the international community may think of the need of a framework convention, which is supposed to, assist WHO or WHO law. And I'm just hoping that something will happen in the General Assembly toward that direction. But I'm not sure if I live long enough to see the result. I'm already 78. I'll be 78 in 2 weeks. So.
Excellent, but we certainly hope that you do. Perhaps one question, though, to finish about international dispute settlement, because I think that's a really important aspect of your project. But more generally in international law, and this topic on epidemics, which you very rightly pointed out, it's so closely related or similar, not closely related, similar to the atmosphere or climate change issues that really have to do, well, with everyone. Everyone should be concerned about them. So one question that you pointed out, or rather problem, is the issue of jurisdiction in case of contentious proceedings. So the question would arise of whether potentially an advisory opinion request might be helpful in the context of this or any other epidemic in the future.
Yes, WHO placed a request to the ICJ for advisory opinion in 1995, and that could be done, but it's not, advisory proceedings is not really strictly dispute settlement between states. And so we need to have a special, system designed to deal with epidemics in the future. And of course, in the field of environmental law, there have been repeated proposals to establish environmental court, and maybe something similar should be worked out for epidemics, because it's really a serious problem anyway for mankind.
Okay, well, thank you very much for fascinating, both fascinating lecture, but also responses, and to see where this project is going. And I'm sure that it will open a debate for years to come. It's obvious. I thank you, everyone. And I think we can now close our session. Thank you very much, Professor Murase.
Thank you very much. Thank you.
Okay. Goodbye.
Bye.